Federal High Court in Abuja on Wednesday barred the Nigerian government from making further deductions from the Federation account to fund the Nigeria Police Trust Fund, NPTF, or other agencies of government not listed in the Constitution. According to Justice Ahmed Mohammed, who delivered the ruling, such deductions were illegal, unlawful, and unconstitutional. Now joining us from Yenagoa, Bayelsa State, to discuss the implication of the ruling, not just for Rivers State, but for all the states and local government areas of the Federation, as well as the Federal Capital Territory, is Somina Johnbull, a lawyer who is conversant with the suit. Good morning, Mr. Johnbull, and welcome to the morning show.
Good morning, Tundu.
Good morning, Somina Johnbull. Thank you for joining us. Well, we're told that you were in court during these proceedings. And yesterday when we discussed it, I said, well, this looks like a straightforward literal interpretation of the provisions of the Constitution in the light of both Section 4 of the Police Act and Sections 161, 162 of the Constitution, which the learned, which his lordship relied on. But what is your own take in this regard? And do you foresee a situation whereby other states, those 35 other states that did not apply to join in the matter, will also go to court?
Thank you, Dr. Abati. What fell for interpretation in that case was the provisions of Section 162 of the Constitution, as well as Section 4 of the Police Trust Fund Establishment Act 2019. Now, the provision of Section 4 actually states that Section 4.1 A and B states that 0.5% of revenue that is paid into the Federation account will actually be paid and deducted for purposes of funding the trust fund. Section the B also states that 0.005% of profits of companies that they're supposed to pay as tax would also be used to pay into the trust fund. Now, what the court, Justice Mohammed, interpreted in that judgment was that by Section 162, all revenues for the Federation should be paid into a Federation account and then should be distributed to the three tiers of government. That's the federal, the states, and the local governments. There is no provision, there's no power that bestows on the National Assembly that these monies should be shared from the Federation account to or deducted or given to any other agency. And that was what fell into interpretation. Now, the implication of that judgment is that as of today, that provision of Section 4 is now nullified, which is the 0.5% from the Federation account and the 0.005% that is supposed to be paid from profits of companies. Now, that has been nullified. So that is actually a judgment in rem. A judgment in rem is a judgment that declares the status of a thing and then is applicable against the whole world. So every state begins to benefit. What the federal government, what the Federal High Court did not grant was the order for other states to get refund. And the court said because they were not parties, that relief cannot be granted. It can only be granted for Rivers State. So all what the states would need to do right now is to apply, not to challenge, not to interpret the judgment, because it is now a judgment in rem. It's now declared as what the law is. So what they will apply for is to sue and then file actions to get refund based on the judgments of the courts.
So my question here is there any chance that the federal government would just reimburse or refund those states without having to file an action? Because even at that point, it's a waste of taxpayers' money since the federal government has had this judicial slap on the wrist. Should all the other 35 attorney generals be put through that process in the first case? And also, I just want to talk about how these things work, because you'll recall that the Attorney General of Rivers State, Professor Adango, first wrote to the Attorney General of the Federation seeking dialogue over this matter, and he was rebuffed, which is what now escalated into litigation. Is there a way to avoid more litigation on this matter, and the federal government should just do what is right? Does it happen that way?
Okay, so first, my opinion on this is the issue that the court interpreted, it's not really a gray area that would even seek further interpretation by going on appeal. So it's really clear. The responsibility that is bestowed on the Attorney General right now is to give advice, so that instead of going through the route of litigation, is to advise that deductions should stop, and then states who actually would want refund should also be refunded without having to go through the rigors of further litigation. I think that should be the proper step that should be taken by the Attorney General of the Federation. There shouldn't be any need to file litigations anymore, because there's the principle that, with these suits, it should actually be an end. There shouldn't be multiplicity of suits. The status of that provision has been declared, and the Attorney General should actually discharge his responsibilities by ensuring that all states that request for refund actually gets refunded.
So I'd like to ask, because this is, and I'm not going to talk about the VAT issue because that's still in court now, but this is coming after that VAT issue. And recently, Governor Kayode Fayemi said, congratulations, this is welcome, and if you see more, challenge it. Can we sort of like litigate our way into restructuring? Because this goes back to that conversation about the powers the federal government have and the powers the state government have. And over the years, the federal government has deliberately taken those powers off the state government, even contravening the Constitution, like in this case, because this was clear enough. So how many more should we do? What are those other contentious issues we can look at and litigate? Is there a possibility of litigating our way into restructuring?
Thank you, Mr. Rufai. And then I think that what we've seen with Nigeria is that it seems that the road to structural or constitutional federalism, it seems to be a little bit tortuous. And so what we've seen is that we've had judicial interventions trying to ensure that we get some form of federalism. And this is actually one step in that direction. We practice a constitutional democracy. And our constitution actually has given to the different arms of government and the tiers of government their functions. So what we see is that in the guise of being a big brother, and then I think that the point should be clear, that the motive behind the trust fund is laudable. However, in a constitutional democracy, the laws must be in consonance with the Constitution that gives you the power that you're trying to exercise, and which is what we see now. So this, for me, is a step in the right direction. And being a step in the right direction, is actually something that should be encouraged. There's still some part of our laws that would need to be improved upon, that we need to challenge, that we do not take for granted. We have also issues about oil and gas, for example, where even at the moment, in the process of trying to challenge even the issue of the exclusive jurisdiction of the federal high courts, to see how state high courts can also entertain, especially for issues that border on fundamental rights. Because in fundamental rights, the federal and the state high courts, they have concurrent jurisdiction. So why can't we file fundamental right actions bordering on oil and gas issues in the state high court? So we are actually taking a judicial route towards ensuring that our federalism becomes better, it becomes stronger, and then becomes more formidable.
I mean, I think that the Rivers State government has been very forward-looking, progressive, proactive in challenging some of the existing laws and practices. And unless you test the law, the court is not going to go out of its way to come and grant you what you have not asked. So it's an example that I think other states should emulate. But what do you think is likely to be the next steps? Is the federal government likely to go on appeal? Or will the federal government respect the ruling of the court?
The difference between this case and the the case on the VAT issue is that the VAT issue doesn't seem to be very, very clear, because there are certain provisions that will support each of the contending sides. And that's what the Court of Appeal is faced with. However, for this particular provision, for this particular case, Section 162 is very clear. Section 162 actually states that the monies in the federation account will be shared between the state, the federal government, the state government, and the local government. Now, the provision for the National Assembly, it says it will share between the states in the manner prescribed by an act of National Assembly. It did not state that it would be the states, the federal, state, local government, and an agency of any of these tiers of government. So it is very, very clear. And so while we concede that the federal government, they have a right to go on appeal, but however, an appeal is actually where there is prima facie a wrong that you are trying to address, which was not, or which is apparent in the face of the judgment. With the greatest respect, I do not think that even a literal interpretation of the provisions of Section 162 does not yield any controversy for which an appeal will serve any utilitarian purpose.
What does this case say to you about our legislative drafting process? Because as far as banana peels go, having this kind of provision that is unconstitutional is a pretty big one.
I think that what this case would actually do, it would also purify the legislative process by the National Assembly. They would have to now check all their laws with the searchlight of the Constitution to ensure that none of the provisions, and like I said, as laudable as it is, none of it contravenes or transgresses the provisions of the Constitution, which is a barometer for which every law will stand or fall. So if a law that is passed and it has laudable intentions cannot stand erect before the Constitution, it will fall flat, like we've seen with Section 4 of this particular law. Now, what can be done is to, why not throwing away the baby with the bathwater, is to get states to make contributions, which is also one of the sources of revenue under Section 4 of this particular of this particular law. But I think that holistically we would benefit all the provisions of bills that will be passed and then accented eventually by the president would actually be subjected to scrutiny or to a litmus test of constitutional compliance.
But, I mean, I'm even more scared, if scared is the right word to use, the fact that there has been no rigor in the way we write our laws in this country. Because if the laws can be subjected to the constitutional barometer and you have faux pas here and there, then what kind of laws are the National Assembly writing? I mean, it was just like this electoral bill that it took civil society to point out 10 different errors of cross-referencing. And these guys get big pays. I mean, what's really happening with the National Assembly?
So, Mr. Rufai, I think that the answer to that will be, what is the basis for qualification or for eligibility, or maybe for someone who wants to, or what do the electors actually look at in electing someone as a legislator? For me, I think it's the National Assembly is like a retirement home for former state executives. It's a place where if you can't get into executive office, they just push you there as a way of settlement. So we've not actually scrutinized and then tried to elect people that would add value to the institution of the legislature. So that brings us to why we just passed some of these laws. It doesn't go through robust debates, robust scrutiny. You do not have, in developed democracies, what you see is that the parliament is usually a place where there are arguments, to and fro, on back and forth. You have sides with strong grounds, predicating their positions, but we don't have it here. And so once we begin to have, and the effect of it is that the outputs would always reflects the quality, with greatest respect to the members of the National Assembly, of the majority in that place. We have not had an institution as a legislature where you look forward to debates. No, I mean, rarely do we have our debates with respect. That hasn't really been enlightening. It hasn't really been engaging and then intriguing. So we would always have all of this. So I think that when we have all these checks, it now comes back to us again as a people. And you're doing a good work, but we need to actually know what qualifies a person to be a judge. It's clear. What qualifies a person to be a legislator, should also be apt upon in selecting or in choosing people that would go into the green or red chambers. And that's not just for National Assembly. Also in the State House Assembly, we have some of these things. But unfortunately, because of the way it is structured, you rarely find local governments challenging laws that are passed by the State Houses of Assembly, because they are actually under the firm grip of the state governments. But there's some form of independence between the states and the federal government. So I think that we need to look again and then begin to canvass the need to get people of quality, people that would project, understand the demands of the legislature in there.
Okay, very quickly, Somina Johnbull, just two quick questions. It was said that you were in court. Maybe if you could define for us very quickly your bona fide in this matter. Were you counsel on the side of the Rivers State government? And then beyond the case, what are your thoughts about police funding in Nigeria? We know that this is about what law, provides for the police trust fund and all of that. But what are your thoughts in that regard, briefly?
Well, my interest in that matter was to hold a watching brief for a client, because the persons affected by that suit are not just state governments but also companies. So that's my interest in that case. The issue of police funding is it's something that we all know that the federal government cannot carry. However, the argument is this: the police, strictly speaking, is an agency of the federal government, and they do not take orders from state governments. So that has also been judicially stated I think in AG Ondo versus AG Federation in the 1980s. However, what the government should do right now is to do what I think is being done by Lagos state government. Create incentives, give incentives to companies, to donate into the police trust fund in exchange for certain reliefs that they can get. Partner with state governments, because every state actually needs the police. The police, every local government, the 774 local governments in Nigeria, they actually need the police. But a police that is not well funded, and then come up with some sort of advocacy. And then there should be transparency in the management of the funds. You would need to, at that point, even get state governments to send representatives in the management of the funds. That's where you get buy-in from state governments, not to legislate upon it. And then get proposed tax holidays, waivers, reliefs, some sort of things that will incentivize companies to give. Not to put it as they've done now that has been annulled in Section 4A as a deduction, and then as a levy on profits of companies.
Thank you very much, Somina Johnbull. I find it very interesting seeing state governors challenging the federal government. I hope someday local government chairmen too will go to court and challenge state governors who also, act ultra vires within their own jurisdiction. But this is useful conversation. Thank you very much.